Yes. Yes, it should be. No. Yes, Mr. Government Advocate. No, no, sir.
ಅಲ್ಲ ಇದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಯ್ತಾ ಬಾಂಡ್
ಅದೇನು ಬಾಂಡ್ ತಗೊಳ್ತೀವಿ more ಕಷ್ಟ ಅಲ್ಲ ವಾಟ್ ದಿ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ದೀಸ್ ಪೀಪಲ್ ದೇ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಅವರ್ ದಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪೇಪರ್ ಮೇಲೆ ಕೈ ಸೈನ್ ಹಾಕಕ್ಕೆ ಕಷ್ಟ ಅವ್ರಿಗೆ
ಅದೇನು ದುಡ್ಡು 1 ಲಕ್ಷ ಕೊಡು ಅಂತ ಕೇಳಿದಾರೆ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಸೈನ್ ಮಾಡೋದು ಅಷ್ಟೇ
Contents of the order passed by this court. Like 27/1/2022. Madam, what's your name? Parinita, yes. The book of offense is shown to submit. The unchecked file cover for the accused. The SVP shall ensure concerned court shall execute the order passed by this court. ಬರ್ಸ್ಕೊಳಕ್ಕೆ ಏನ್ ಕಷ್ಟ ಇವ್ರಿಗೆ ಏನು ಹಾ 1 week. Yes, 1 week. 1 week. Sorry. Yes. What is this police report? Then we will ask this police officer to present the report. This is not executing. One case of parvagilla. What is it? Kapakodi, orally. Yes, 5. What is this non-compliant office objection?
That will be complied with the second set. That has been furnished.
Ah.
That come up for the last occasion, would consider that they take up today.
There are 2 objections. Reference under 482. Second page in special case number so not working coming in second set. Page numbers 34 to 37 in second set.
There are so many objections.
Some pages are missing in the second set.
References on the aspect numbers.
Yes.
In 482 reference is made.
Reference both under the 482 as well as under the revision. References numbers. One reference is by
These are all the second set actually. Second set failed. Papers not failed.
and one more reference is by this Lordship Justice Sandesh.
Yes, yes, you have passed the order last time. You have not filed second set in your matter, Mr. Senior Counsel. 9778. 6.2.
Second set file ಆಗಿದೆ. Acknowledgement ಇದೆ. 18th January 2022.
Lano Senior Counsel. Sandesh Senior Counsel on instruction submit that second set already filed for the office on
18/1/2022.
18/1/2022. The office check and post for the court. ಯಾಕ್ರಿ 18 to ಎಷ್ಟು ದಿವಸ ಬೇಕಾ? ನೋಡಲ್ಲ ಅವರು.
All other papers, to be documents to be filed.
ಯಾವುದು ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್?
Can check papers.
Ah.
Maybe IAG.
ಅವರು let them raise a specific objection. ಜನರಲ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ.
ಇಲ್ಲ, I'll get it very.
ಹಾ ಬರ್ಲಿಪ್ಪ. ಎಸ್ ರೀ, ಕರ್ಸಿ ಯಾರೋ ಹೂ ಇಸ್ ಇನ್ ಚಾರ್ಜ್. ಸರ್ ಹಾಸ್ಪಿಟ್ಲ್ ಹೋಗಿದ್ದು ನಾವು ವೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅವ್ರು ಬರಂಗಿದ್ರೆ ಮಾತ್ರ ಕಾತೀವಿ. ನೀವು ಹಾಸ್ಪಿಟ್ಲ್ ಹೋಗಿದ್ದಾರೆ, ಪಕ್ಕದ ಮನೆಗೆ ಹೋಗಿದ್ದಾರೆ, ನಮ್ಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ. ಎಸ್ ಚೋಟ, we went to hospital, we don't know what time you will come.
ಯಾರು?
We are submitting is what the state is submitting. And Mr. Deshpande will submit that the NDPS Act, that is specific provision of.
ಅರ್ಜಿ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ ನಾವು.
We can, difference will be on a short focus with the we can very easily.
BCC ಪವರ್ ಇದೆಯಾ ಇಲ್ಲ ಕೋರ್ಟ್ ಪವರ್ ಇದೆಯಾ ಅಂತ.
Whether DTC has the power or whether the court has power, this is all the aspect for consideration. Based on the various rulings, we will try and point out whether by contention.
ಪಾಸ್ ಅವರ್. ಟೋಟಲ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ನಾವು. ದಿಸ್ ಇಸ್ ಪವರ್ ಇದೆ, ಇದು ಪವರ್ ಇದೆ.
7.
This report being served. The father serve ಮಾಡೋದಾಗುತ್ತಲ್ರಿ ನೋಟಿಸ್. ಅದು ನಮ್ಮ CPC ಇದ್ದಂಗೆ.
ಅವನೆಲ್ಲೋಗಿದ್ದಾನೆ ಅಂತ ಬರ್ದಾಕಿದಾರ, ಅಕ್ಯೂಸ್ ಎಲ್ಲೋಗಿದ್ದಾನೆ ಅಂತ ಬರ್ದಿದಾರ ನೋಡಿ.
The impeding.
ವಾಪಸ್ ಬಂದೇ ಇಲ್ಲ, ಕೆಲ್ಸಕ್ಕೆ ಹೋದವನು ವಾಪಸ್ ಬರ್ಲಿಲ್ಲ.
ಕೆಲ್ಸಕ್ಕೆ ಹೋದವನು ವಾಪಸ್ ಬಂದಿಲ್ಲ, ದಟ್ ಇಸ್ ವಿಚಾರ.
ಅಲ್ಲ ಇದೆ, ಬಟ್ ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗೋದಿಲ್ಲ ಅಂತ.
ಅವರು ಬರ್ದಿರೋದು ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ, ಬಂದಿಲ್ಲ. To press notice in of the report submitted by the police, judicial police, issue press notice to the respondent accused now to give one more opportunity, and the police, judicial police shall ensure some notice to the accused or with a proper endorsement. I1 notice. Issue notice on I1 2022. ಅವ್ನು ಕೇಳ್ಬೇಕಲ್ಲ, ನಾವು ಅಲ ಮಾಡಕ್ ಮೊದ್ಲ. I1 2022 filed including by the complainant, include the complainant. I1 2022 filed by the state to include the complaint. Yes, sir, proper party. In your province of section party law, Fox Act. According accepting cost showing application accompanying update IA1 2021 is allowed. The impeding applicant complaint is impeded as party. Issue notice to the complaint. ಅದು ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬಿಡಿ ಇವಾಗ. Yes. As it permitted to amend cost statement. Yes, what is this? Yes, sir. All right. What is the vote as against him? Merely arrested, release is not a ground for suspension. It is section 302. Huh? No? Then with number 1. Forehead. That is number 2, assault with Picasso. Previous injury. Not back injury. Henry. ಅವರು ಹೇಳಿದಾರಲ್ಲ. This is by A1. Yes. Only operation.
It is septic shock. Injury sustained.
Ultimately, report is compression of head injury sustained according to the post-mortem report. Exit reporting. Head injury.
Injury in the Satyarudanda.
Grant F4, reject F1. Mama. Where is the bail granted to accused number 2? The present appeal. Kailasa, accused number 1. Kailasa Kalsana Amma. A4. So, the number 1 and 4. File the present application under section 389 Court of Karnataka. Based mainly on the ground that there are no war tax against the accused 1 and 4. Prosecution proved, failed to prove the case was prosecuted beyond reasonable doubt. 18 witnesses examined by the prosecution. PW1 Chandru, PW2 Siddharaju are alleged eyewitness to the alleged incident. We have not supported case of prosecution. They have turned hostile. they have been connected on with prosecution, but they have denied government's meat. assaulted the deceased with the MO 1. MO two clubs on the forehead of the deceased, thereby caused the following injuries. Page 32 ನಲ್ಲಿ. Point number 1. Point number 2, 3, 4. The doctor, April 14, to examine the disease showed him report exit report. Specifically find that death caused due to septic shock as a complication of head injury sustained. Pneumonia is caused complication of head injury. Accordingly, I should postmortem exit report. There is a clear or tax against the number 1 who caused head injury, thereby disease. Therefore, if the number 1 is not entitled any bail, though was granted bail evidence of the trial as the present application is filed post conviction. The powers of suspension sentence and grant of bail is 389. The court should be cautious if the prima facie case, the court should not grant the finding of guilt. The Honorable Supreme Court time and again held that the question of presumption innocent does not arise, nor is the principle of bail being the rule and jail exceptions attract once there is a conviction upon trial. Rather, the court considering the application for suspension or grant of bail has to consider prima facie merits of the appeal coupled with the other factors. There should be a strong compulsory reason for grant of bail, notwithstanding an order of conviction or suspension of sentence, and the strong and compelling reason must be recorded in order to bail as mandatory section. Yeah. Since there is a word tax, by P.W. 14 and Exhibit 14 clearly depicts that the act number 1 cause the death of the deceased not entitled to 28 to 9. Accordingly, the application filed by the accused number 1 is liable to be rejected. Stop. Mr. In the present case, the allegation is against accused number 4 that he has assaulted the back of the deceased with the MO1, thereby some operations, right upper back, lower back horizontally pressed. The cause of death as P and Exhibit 14 PM report clearly that the cause of death was due to septic shock as a complication of head injury sustained made by the accused number 1. As the accused number 4 was on bail throughout prima facie, the accused number 4 made out a case to being a lady, made out a case to grant the bail put up. The accused number 2 also arrested and released on bail by this court by separate order. Stop. Prima facie, the accused both made out a case. Thereby it is entitled to grant of bail. So in the above, IA 1 2021, filed by the accused number 1, he is thereby rejected. IA number 1 filed by rejected in part. And IA 1 2021 filed by accused number 2, accused number 4 is allowed. And is entitled to grant of bail subject to following conditions. The accused number 4 shall execute a personal bond for rupees 1 lakh with 2 sureties for like sum to satisfy judicial court. What is the fine amount? The accused number 4 shall pay the fine amount imposed by itself. The accused number 4 shall be present before the court as and when required. Yes. Yes. You are the husband. You are the sole accused. Yes. For 98 302. All the sections. Yes, yes. 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 Correct. Correct. Life ಕೊಟ್ಟ ಅವೆಲ್ಲ ಅದ್ರಲ್ಲಿ ಬಂದ್ಬಿಡ್ತಾವೆ ಅಂತ ಹೇಳಿದಾನೆ. All right. I should impose punishment on each section. ಮಾಡ್ಬಿಡಿ ನಾವು. ಹಾ 350. ಹಾ ಕರೆಕ್ಟ್. ಓದ್ಬೇಡ್ರಿ, ವಿಚ್ ಇಸ್ ದಿ ಪಾಯಿಂಟ್ ವೈಲೇಷನ್. ಹಾ you take advantage. Why you bother? There's no order. There's no order. Why you bother? That is not a ground for grant of bail. Cannot to convicted. Lay out.
But this is not the case of homicide. It may be the case of suicide, which is evident from the testimony of PW, whether or not she complained father.
According to you, it is suicidal.
It's of suicide, not homicide. testimony of the PWO complainant. But he admits that
What is the next point?
PWO but he has seen the dead body hanging from the window. That was his body.
That body was hanging. All right.
And not the accused was present outside, not inside.
ಹಾಕ್ಬಿಟ್ಟು ಆಚೆ ಬಂದವನು ಹಾಕ್ಬಿಟ್ಟು ಆಚೆ ಬಂದ್ತಾನೆ.
ಹೊರಗಡೆನೆ ಇದ್ದು ಡೋರ್ ನಾವು ಕಟ್ಟಿ ಬ್ರೇಕ್ ಓಪನ್ ಮಾಡಿ ಹೊರಗಡೆ ಹೋಗ್ತೀವಿ ಅನ್ನೋದು. Another issue, Lord, the evidence of PW10, Lord, the doctor who has conducted postmortem. Then, Lord, she says she has not noticed any bruise and no nail marks over neck.
No, not noticed.
She had not seen compression on neck due to strangulation.
ಏನ್ ಹಾಕೊಂಡೆ ಸ್ಟ್ರಾಂಗ್ಲೇಟ್ ಆಗುತ್ತಲ್ಲ.
ಬಾಗಿಲು ಹೊಡೆದು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಯಾರು ಹೇಳ್ತಾರೆ?
ಎಲ್ಲಿದೆ ಬಾಗಿಲು ಹೊಡೆದು ಹೊರಡೋಗಿದೀವಿ ಅಂತ? ಬಾಗಿಲು ಇವ್ನು ಔಟ್ ಸೈಡ್ ಇದ್ದ, ಬಾಗಿಲು ಹೊಡೆದು ಬಿಟ್ಟು ಒಳಗಡೆ ಹೋದ್ವಿ, ಇನ್ಸೈಡ್ ಲಾಕ್ ಆಗಿತ್ತು. ಎಲ್ಲಿದೆ? ಟೈಪ್ ಕಾಪಿ.
ನಮ್ಮ ಅಕ್ಕನಾದ ಮಗುವ ಆಡುತ್ತ ಅಂತ
70 ಪೇಜ್ ನಂಬರ್ 70 ಅಲ್ಲಿ.
ನಮ್ಮ ಅಕ್ಕನಾದ ಮಗುವ ಆಡುತ್ತ ಜೋರಾಗಿ ಕಿರಿಚಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ನಂತರ ನಾವು ಬಾಗಿಲನ್ನು ಬಡಿದಾಗ ಬಾಲಚಂದ್ರ ಮತ್ತು ಮಧುರ ಅವರು ಮನೆಯಲ್ಲಿ ರೂಮ್ ಒಳಗಡೆ ಹೋಗಿ ರೂಮ್ ಬಾಗಿಲು ಹಾಕಿಕೊಂಡು ಹೋಗುತ್ತಾರೆ.
ಇಬ್ರು ಇದ್ದಾರೆ ಒಳಗಡೆ.
ಇಬ್ರು ಇದ್ರು ಒಳಗಡೆ.
ಬಾಲಚಂದ್ರ is the accused. They are inside the house. Both.
ಅದನ್ನ ಕೆಳಗಡೆ ಇದೆ. ಪಕ್ಕದ ಮನೆಯ ವಾಸಿಗಳಾದ ವೇಣು ಶ್ರೀನಿವಾಸ್
ಅಶ್ವಿನ್ ಅವರು ಮನೆಯ ಮುಂದೆ ಇದ್ದು ಮಧುರ ಅವರಿಗೆ ಆಗಾಗ ಜೋರಾಗಿ ಚುರುತ್ತಿದ್ದಾಳೆ.
ಅಶ್ವಿನಿ ಮನೆ ಮುಂದೆ ಬಚ್ಚಲು ಮನೆ ರೂಮಿನಿಂದ ಮಧುರ ಕಿರಿಚುತ್ತಿದ್ದ ಯಾವುದೇ ಶಬ್ದ ಕೇಳಿಸಿಲ್ಲ. ನಾನು ರೂಮ್ ಬಾಗಿಲು ಬೆಳೆದಾಗ ರಾಮಚಂದ್ರ ಅವರು
ತೆಗೆಯದ ಕಾರಣ
ಅನುಮಾನದ ಬಾಗಿಲನ್ನು ನಾನು ಪಕ್ಕದ ಮನೆ ವಾಸಗಳ ವೇಣು ಫೋನ್ಸು ಬಾಗಿಲನ್ನು ಜೋರಾಗಿ ತಳ್ಳಿ ಬಾಗಿಲು ತೆಗೆದು ಬಾಲಚಂದ್ರ ಮೊದಲ ಕತ್ತು ಇಸ್ಕುತ್ತಿದ್ದರು.
ಅಲ್ಲ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಬಾಗಿಲು ಬಡ್ದು
ಮಧುರ ಅವರು ಯಾವುದೇ ಚಲನವಲನವಿಲ್ಲ ಬಿದ್ದಿದ್ದರು. ಅಶ್ವಿನ್ ಜೋರ ಹಾಕಿದ್ದು ಅಕ್ಕಪಕ್ಕ ಮನೆ ಬಂದು ಯಾವುದೇ ಉಸಿರಾಟವಿಲ್ಲವೆಂದು ಬಲಗೈ ಮೊಣಕಾಲಿ ತರಿಸಿದ ಗಾಯಗಳಾಗಿದ್ದು, ಕೆನ್ನೆಯ ಮೇಲೆ ಕೈಯಿಂದ ಒಡೆದ ಗುರುತುಗಳು, ಕತ್ತಿನ ಬಳಿ ಒಂದು ಕನ್ನಬ ಗುರುತು ಕೆಂಪಾಗಿ ಕಾಣುತ್ತಿದ್ದು ಸತ್ತು ಹೋಗಿದ್ದಾಳೆ. ಇಲ್ಲಿ ಹೊಡೆದಿದ್ರೆ ಅದೇನು ಇಲ್ಲೇನು ಬೇಕಾಗಿಲ್ಲ, ಇಲ್ಲಿ ಹೊಡೆದ ಫಿನಿಶ್. ಎಸ್ was on bail. ಕಾನೂನಿಗೆ ಫೈನಾನ್ಸಿಯಲಿ ಏನು ಬರೋದಿಲ್ಲ. They are not necessary. No, they are not necessary to engage Ismail before the trial court. We have a legal authority, legal service authority will give free legal aid. Finance ಇಲ್ಲದೆ ಇದ್ರೆ ಒಂದು ಲೆಟರ್ ಬರೆದು ಸಾಕು ನಾವು ಕೊಡ್ತೀವಿ. ಖುಷಿ ಪಡ್ಬೇಕಲ್ಲ ನೀವು,
ಬೇಗ ಮುಗಿಸಿದ್ದೀವಿ.
ಬೇಗ ಮುಗಿಸಿದಾರಲ್ಲ. ಅಲ್ಲಪ್ಪ ನೀವು ಯಾವ ಬೋನಾದ್ರೂ ಮಾಡಿ ಸಂತೋಷ ನಮ್ಗೆ. ಇಸ್ಮಾಯಿಲ್ ಪ್ರೋಬೋನ್ ಅಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಕಾಂಟ್ ಬೇಲ್ ಸಮಥಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಶೋಸ್ ಸಮಥಿಂಗ್ ಅಗೇನ್ಸ್ಟ್ ಯು. ಕಂಪ್ಲೇಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಶೋಸ್ ಅವರೆಲ್ಲ ಕತ್ತಿಸ್ತಾ ನಾವು ನೋಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ವ?
ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾನಲ್ಲ, ಇವಾಗ ನೀನ್ ಓದ್ದಲ್ಲಪ್ಪ, ಇವಾಗ ನೀನ್ ಓದಿದ್ದು ಆತರ ಇಲ್ಲ. Who is this ಶಿವಣ್ಣ? ಅವ್ರು ಹೇಳೋದು, ನಾನು ಬಾಗಲು ಬಡ್ದಾಗ ಬಾಲಚಂದ್ರ ಹಾ ನಮ್ಮ ಅಕ್ಕನಾದ ಮಧುರ ಅಳುತ್ತಾ ಜೋರಾಗಿ ಕಿತ್ತೋದು. ನಂತರ ನಾವು ಬಾಗಿಲ ಬಡ್ದಾಗ ಬಾಲಚಂದ್ರ ಮತ್ತು ಮಧುರ ಇವರುಗಳು ಬಾವಿಯಲ್ಲಿ ರೂಮ್ ಒಳಗಡೆ ಹೋಗಿ ರೂಮ್ ಬಾಗಿಲು ಹಾಕೊಂಡಿರ್ತಾರೆ. ತೋರಿಸಿ, ನೀವ್ ಹೇಳಿದ್ರಲ್ಲ he was outside. ಅವ್ರ ಅಪ್ಪ PW1 ನೋಡಿದಾಗ ಹ್ಯಾಂಗಿಂಗ್ ಇತ್ತು, ಇವನು ಔಟ್ಸೈಡ್ ಇದ್ದ ಅಂತ. ಬಾಗಿಲು ಇನ್ಸೈಡ್ ಅಲ್ಲಿ ಡೋರ್ ಹಾಕಿತ್ತು, ಸಾಕು ತೋರಿಸಿ. Yes.
I can say more than I know. At the time of incident, I had been to shop for purchasing Maila at about 4:30 PM to 5 PM. I was at shop for half an hour. I returned back home at 5:30. At the time, accused told me that my daughter was in school, but what is the road?
ಅವನು ಹೇಳ್ದ ಅಂತ ಹೇಳ್ತಾರ.
I viewed through window that my daughter is in hanging position. Thereafter, the accused removed the daughter hanging inside the room and laid her on the floor.
ಬೋಲ್ಟ್ ಹಾಕಿದ್ಲದ್ದು ಎಲ್ಲಿದೆ?
By bolting the door inside and
Yes sir. ಬೋಲ್ಟ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಾಳೆ. Where's that?
ಅವ್ರು ಹಾಕ್ಲಿಲ್ವಾ? ಹಾಕ್ಬೇಕಲ್ವಾ ಇವ್ರೆ?
ಕೊಡಿ PW ಎಲ್ಲಿದೆ?
ರೆಕಾರ್ಡ್ ಇದೆಯಾ? ಕೊಡಿ.
ಎಲ್ಲ ಹಾಕ್ಬೇಕ್ರಿ, ನಿಮಗೆ ಫೇವರ್ ಆಗಿದ್ದು ವಿರುದ್ಧ ಎರಡು ಹಾಕ್ಬೇಕು. ಯು ಕ್ಯಾನ್ ಫಿಶ್ ದಿ ಕೇಸ್. ಆಲ್ ರೈಟ್, ನೋಡೋಣ.
If he is not inside, he was outside.
ಹಾ ಅಪ್ಪ ಇರಲಿಲ್ಲ, ಆಮೇಲೆ ಬಂದಿರೋದು. 4, 3 and 4. PW2 and are my parents. Sister, deceased Madhura is my sister. Accused was husband. After 2 years back, Madhura accused for perform. The accused demanded dowry, cash of 50 lakhs at the marriage. We gave in marriage 1 lakh for 2 years for. Accused came to our house. At that time, Surendra, myself were in our house. At the time, accused made galata with his wife. When you asked him as why you would make galata, at the time, accused replied to why you were intervening their personal life. Carried victory, Madhura came out of the room, sitting outside the room. We heard noise from inside the room. After some time, noise inside the room was stopped. We insisted upon the open the door. At the room, but it was not open. When we called neighbor CW 8 so and so, they came open the door, breaking. We went inside, saw the accused keeping his hands on the neck of my sister. We physically checked and confirmed my sister no more. We saw the marks, assault on cheeks of my sister. My father came and inquired as to what happened. I reported the incident. My father lodged a complaint. Police came to the spot, seized broken bangle pieces, shirt buttons from the spot. Yes, sir.
There are 22 of the judgment.
61 statement, my lord.
161 statement we can't take.
ಅದರಲ್ಲಿ ಏನು ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
ಅದನ್ನ ನೀವು ಕನ್ಫರೆಂಟ್ ಮಾಡಿಸಿಲ್ಲ. ಅದನ್ನ ನೀವು ಕನ್ಫರೆಂಟ್ ಮಾಡಿಸಿಲ್ಲ ವಿಟ್ನೆಸ್ಗೆ.
ಡಾಕ್ಟರ್ PW.
ಮತ್ತೆ
Judgment ಅಲ್ಲ
30 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ 30.
ಇಬ್ರು ಹೇಳ್ತಾರೆ. Ligature marks on the center of the neck. ಅದೊಂದು ಹೇಳ್ತಾನೆ ಇಲ್ಲಿ ಹೇಳ್ತಾನೆ ligature marks on the neck, measuring so on. Bleeding, cutting, bleeding, removing spots, ligature mark, crush. Strangulation mark ಇದೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ದಲ್ಲ ರೀ ನೀವು ಸ್ಮೈಲ್.
ಚಿಕ್ ಮೇಲೆ ಗಾಯ ಇದೆ, ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ.
Measurement 8 centimeters to 2 centimeters.
Page number 42, para 30. ಅಲ್ಲಿದೆ ನೋಡಿ ಎಲ್ಲ.
That's all smile. Sorry, sir. Something against you. The PW 3 and 4, they are eyewitnesses. Father is only a complaint, thereafter he came. By that time he was outside.
Never say anything.
Not at this stage, sir.
ನೀವು ಅದನ್ನ ಕನ್ಫರೆಂಟ್ ಮಾಡಿಸ್ಬೇಕು, ಹೇಳ್ಕೊಡ್ಬೇಕಾ ನಾವು.
126. After class 126.
Judgment of paper book. Is all 120. Yes.
Cross-examination. I have seen compression on neck due to strangulation. But no, I have not seen swelling issues. there were no nail marks over the neck. It may be true that in case of land strangulation, there will be chances of writing gold color, which is not. But it is possible. Another thing we are next day. Any person is killed by pressing neck. Injury over the neck of victim is not possible. Here, my lord, and this is next page, my lord, 125 medicine. Ligature mark C in the center of neck, measuring 8 centimeters to 2 centimeters.
Yes.
Pressure on cheek here, operation on ligature mark.
Then what is your 3-1 statement? When you are there on the wife, who killed your wife?
But I was not present inside.
That is P3 and 4. 3 and 4 says they are eyewitness to the incident. You go inside, they came outside, they were watching.
But they
He
have
says, you will never come. That is the evidence.
not seized, my lord.
That is on merits.
Another important issue, what all they have recovered is 3 things. MO1 is a shut button. MO2 is a piece of.
Sir, you are not on merit, sir. This is a post-conviction matter. While considering IA, we should make out a prima facie case.
We are satisfied.
Prima facie, something against you. Is it a case to grant? Anything such as an honor you.
This injurious force, Lord, is
It
not.
will be decided on merits.
Not annual strangulation. The 8 centimeters.
Mr. Ismail, when your wife died, you are inside the house. What is your explanation? 313. ಅವಳೆ ಹಾಕೊಂಡು ಹೇಳಿದಿರಾ ತೋರ್ಸ್ರಿ 313 ತೆಗಿರಿ.
Even I have produced, Lord.
ಏನ್ ಹೇಳಿದಿರಿ? ಟೋಟಲ್ ಡಿನಯಲ್. ಎಲ್ಲ ಸುಳ್ಳು 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 ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
Forget about dowry. What
We are
about
not
the death?
concerned. Dowry is concerned only 302 now.
What about death?
ನಿನ್ನ ಹೆಂಡತಿ ಹೆಂಗ್ ಸತ್ಲು? ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಮದುವೆ ಆಗಿ? ಅದಕ್ಕೆ 304 ಬಿಟ್ಟು ಆಗ್ಲಿಕ್ತಾರೆ. ಅವರು ಈ ಪಾಯಿಂಟೆಡ್ ಔಟ್ when 498 304 other sections ಇದ್ದಾಗ ಟ್ರಯಲ್ ಕೋರ್ಟ್ has committed only 302, not other. Each punishment has to do it.
Higher
ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ 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 ಹಾಕಿ. Again, hint, they are now the point appeal. Remaining seconds ಗೆ. ನೀವು ಸುಮ್ಮನೆ ಅಲ್ಲ ರೀ.
ಅಲ್ಲ, ಯಾವ ತರ
ಅವ್ರು
provision ಇದೆಯಾ?
ಅವ್ರು ಹಾಕ್ತಾರೆ ಇವಾಗ.
ಆ ತರ ಏನಾರ ಪ್ರಾವಿಷನ್ ಇದೆಯಾ? ಒಂದ್ರಲ್ಲಿ ಮಾಡಿದ್ರೆ ಸಾಕಂತ ಮಾಡ್ಬೇಕು.
Each separate ಅವ್ರು ಹೇಳಿದ ಪೇಪರ್ ಅಲ್ಲಿ ಅಷ್ಟು otherwise state if not filed will allow him, that's all. You can't convert without appeal filed by state. Only 302 ಡಿಸೈಡ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ಮಿಕ್ಕಿದೆಲ್ಲ ಏನೂ ಮಾಡೋದಿಲ್ಲ ಅಷ್ಟೇ. If you are not filed any ಅದ್ರ ಮೇಲೆ ಕನ್ವಿಕ್ಷನ್ ಬರೋದಿಲ್ಲ.
ಟ್ಯಾಗ್ ಮಾಡಿ.
That's all, Ismail. That is not issue now. Death is no issue before us. She died, your wife died within 2 years. How your wife died? You should say something.
She has committed suicide. I was the one who has removed the body. It's not PW.
ಅದನ್ನ ನಾವೇ ಹೇಳ್ತಾನೆ ಆಮೇಲೆ ತೆಗೆದು ಅಂತ.
At the time of ನೋಡೋಣ ಬಿಡಿ.
ಸತ್ತ ಮೇಲೆ
ನಾನು ಹೋಗಿ ತೆಗೆದಿದ್ದೀನಿ.
ಹೌದು ನಿಮ್ಮ ಮಾವ ಮೇಲೆ ತೆಗೆದಿದ್ದೀರಾ?
ಹೌದು.
ಅವ್ರ ಹೆಣ್ಮಕ್ಳು PW3 and 4.
I was not at all present inside of the room, not as alleged by PW3.
That will be decided on merit, sir. Where you have examined the PW3 and 4 and elicited that you are not in the room. 3 and 4 ತೋರಿಸಿ. ಅವರು ನಮ್ಮ ಭಾವ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲಿ 3 and 4 ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗಿದ ಕೇಸ್.
Do not produce the deposition of PW3 and 4.
Yes, sir. At all. ಇಲ್ಲ ಇದೆ. ಒಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ in all fairness you should have produced all the annexes, all the depositions. ನೀವು ಯಾವ್ದು ಬೇಕಾದ್ ಹಾಕೊಂಡು ಇದು ಮಾಡಿದ್ರೆ that is according to you, PW1 is enough. According to government advocate, PW3, 4 and is enough to convict. Yes. We'll consider that. ಏನ್ರಿ ಹೇಳ್ತೀರ ಡಾಕ್ಟ್ರು ಏನೋ ಹೇಳ್ತಾನ ಡಾಕ್ಟ್ರು ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಬಟ್ಟೆ ಹಾಕೊಂಡು ಗೊತ್ತಿರ್ಬೇಕು
ಏನ ಕೈಯ
On the case, my lord, she has committed suicide in bail in the room. Press, manual press running, what this injury won't find 8 centimeter into 2 centimeter, extending from 5 white particles to what?
ನೋಡ್ರಿ ಮೆತ್ತಗ್ ಬಟ್ಟೆ ಹಾಕಿ ಪ್ರೆಸ್ ಮಾಡಿದ್ರೆ ಸ್ಟ್ರಾಂಗ್ಯುಲೇಷನ್ ಬರಲ್ಲ ಏನು ಬರಲ್ಲ
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೈ ಹಾಗಾಗಿ ರಿಕವರಿ ಮಾಡಿಲ್ಲ
ಕೇಸ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ನೀವು ಪ್ರೆಸ್ ಮಾಡಿದ್ರಿ ಕೈಯಲ್ಲಿ ಏನ್ ಕೈ ರಿಕವರಿ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ ಏನ್ ಕೊಡ್ತೀವಿ PM ಕೊಡ್ತೀವಿ ಎಸ್
When you say like para 10 of PW.
The PM report also says ligature mark seen on the center of the neck measuring 8 cm in 22 cm.
ligature mark ಅಂದ್ರೆ
neck hair ಇತ್ತು ಅಂತ ಹಿಂದೆ ಇದೆ hanging ಮಾಡ್ಕೊಂಡಾಗ ಮಾತ್ರ ಇದು
Cause of death auspicious result of strangulation.
ligature mark ligature mark ಅಂತ ಹೇಳಿದಾರಲ್ಲ ಎಲ್ಲಿ ನೀವು ಇದೇ ಮಾಡಿಲ್ಲ ಸೀಸ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಆಗುತ್ತೆ ಅದು
ಎಲ್ಲಾ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಲಾಯರ್ ಹೇಳಿರ್ಬೇಕು ಎಲ್ಲದಕ್ಕೂ ಸುಳ್ಳು ನೀವು ಒಂದ್ ಕಡೆ ಇದಾದ್ಮೇಲೆ ಸ್ವಾಮಿ ನಾನು ಅವಾಗ ನಮ್ಮ ಮಾವನ ಇದ್ರು ಆಚೆ ನಾನು ಆಚೆ ಇದ್ದೆ ಅವ್ರು ನೇಣಾಕೊಂಡ್ಬಿಟ್ಟು ಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ಬೇಕು ಎಲ್ಲ ಸುಳ್ಳು ಸುಳ್ಳು ಅಂತ ಹೇಳಿದಿರಿ ಕೊನೆಗೆ ಯು ಸೇ ಎನಿಥಿಂಗ್ ಮೋರ್ ಅಂದ್ರೆ ನೋ ಇಲ್ಲ have any defense ಇಲ್ಲ ನೀವು ಮೆಕ್ಯಾನಿಕ್ ಸೇವೆ ಮಾಡ್ಬೇಕಪ್ಪ ಮೆಕ್ಯಾನಿಕ್ ನೀವ್ ಯಾಕೆ ಮಾಡ್ತೀರಿ ನೀವು ಲಾಯರ್ ಲರ್ನಡ್ ಮೆಂಬರ್ ಆಫ್ ದಿ ಬಾರ್ ಜಡ್ಜ್ ಮೆಕ್ಯಾನಿಕ್ ಮಾಡಿ ನೀವು ಯಾವ ರೈಟ್ ಅಲೌಡ್ ದಟ್ ಮೆಕ್ಯಾನಿಕ್
ನಂಬರ್ ಮೀಟಿಂಗ್ ಮೆಟೀರಿಯಲ್ ಇದೆ
PW3 ಬಗ್ಗೆ ಹೇಳೋದು
ಮಾಡ್ಬಿಡಿ
32
heard the noise from inside the room. Doctor sometimes noise inside the room was stopped. They insisted.
ಅವರಿಬ್ರು PW3 PW4 ಹೇಳಿದಾರೆ ನಿಮ್ ಬಗ್ಗೆ ಅಂದ್ರೆ ನೀವು ಸುಳ್ಳು ಅಂತೀರಾ ನಾನು ಮನೆಯಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಆನ್ಸರ್
ವಾಟ್ ಯು ಸೇ ಅಂದಾಗ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾಗಿತ್ತು
ವಾಟ್ ಯು ಸೇ ಅಂದ್ರೆ ಸುಳ್ಳು ಅಲ್ಲ ನಾನು ಇರ್ಲಿಲ್ಲ ಹೇಳ್ಬೇಕು ಮನೆಯಲ್ಲಿ ನೀವೆಲ್ಲದಕ್ಕೂ ಸುಳ್ಳು ಸುಳ್ಳು ನಾವೇನ್ ಮಾಡಿದ್ವಿ
ಅವ್ರು ನೋಡಿಲ್ಲ
ಆಲ್ ರೈಟ್ ದಟ್ಸ್ ಆಲ್
ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ ನಾನು
ಯಾವ ಪ್ಯಾಲೆಟ್ ಅನ್ನಪ್ಪ ಯಾವ ಪ್ಯಾಲೆಟ್ ಅನ್ನು
last 5 lines we attempted to open the door but it was not open as such we heard neighbor the door of the room was bolted inside The door was opened by breaking it. The neighbors went inside and verified the body of my sister laying on floor and confirmed that she was normal. She
Correct.
not saying it was she has seen. ಅದು ಲಾಕ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ
ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
ಅವ್ನು ಹೊರಗಡೆ ಇರ್ತಾರೆ. ನೋಡಿ,
Please read paragraph 3 of the PWC evidence. ಎಲ್ಲಬೇಕಲ್ಲ ಓದ್ಬೇಡ್ರಿ. You can't choose words. You should read the entire the deposition, both examination and examination, then you can come to conclusion, not one word. ಈ 5 years law ಓದ್ತಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಓಡೋಗ್ಬಿಟ್ಟು ಬೇಡ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಗೆ ಒಂದೇ ಒಂದು ಏನೋ ಬಿಟ್ಟು ಅದನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮತ್ತೆ ಹೊರಗಡೆ ಅವ್ರು ವಿರುದ್ಧ ಇರುತ್ತೆ ನೋಡಲ್ಲ ಅವ್ರು. ರಾತ್ರಿ ಓದ್ರಿ.
On 10/5/2020 at about 4 p.m., accused came to our court. At that time, CWC and CWC, Surendra and myself were inside. We were two witnesses ಮಾಡಿಲ್ಲ. CWC and 10 were seen.
ಅದು on merit she may succeed.
At that time, accused made galata with his wife. He asked him as to why he would make galata. At that time, accused replied as to why we were intervening in their personal life. CWC carried daily of Mudra and came out of the room and sitting outside the room. He heard the noise from inside the room. After some time, noise inside the room was stopped. It is to room of the room. But neighbors, but is a lot of persons not will be made as a witness.
It's all right.
Or ignorant.
You are there.
You cross-examine.
You are there. You are there along with your wife.
ನನಗೆ ಅರೆಸ್ಟ್ ಮಾಡಿರೋದು
When we went inside, saw accused keeping his hands on the neck of my sister.
cross-examination.
Paragraph 13 ಓದಿ. Yes, yes.
Paragraph 10 is the last final.
ಓದಪ್ಪ.
He attempted to open the door, but it was not open. As such, we called neighbors, Andre, CW10 and
All right.
the door of the room was bolted inside. The door was opened by breaking it. The neighbors went inside. She's not saying she went inside.
All right, not
The
necessary.
neighbors went inside and verified the body of my sister laying on the floor and confirmed that she was no more. I did not make efforts to call my father. Because nobody says that I was inside.
Read paragraph 13.
It is false to say that the accused never made any galata with his wife. It is false to say that on 10/20 accused have not visited our house. It is false to say that the accused.
You went to the house of PW3. ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ. ಓದಿ. It is false.
ನನಗೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರ ಊರಲ್ಲಿ ಅವ್ರ ಮನೆಯಲ್ಲಿ
ಏನ್ ಮಾಡ್ಕಾಗತ್ತ ಅವ್ರು ಹೆಣ್ಮಕ್ಳು
they would have killed me.
ಒಳಗಡೆ ರೂಮ್ ಅಲ್ಲಿ ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ಯಾರು ಬರ್ತಾರ್ರಿ? ಪ್ರೈವೇಸಿ ಯಾರು ಬರೋದಿಲ್ಲ. ಎಲ್ಲ ಗಂಡ ಹೆಂಡತಿ ಮಾತಾಡ್ಕೊಂಡು ಬಿಡುವಂತ ಬಿಡ್ತಾರೆ. ಆಮೇಲೆ ಹೇಳಿದ್ದೀರಿ ವೈ ಆರ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಪ್ರೈವೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಹೇಳಿದ್ದೀರಾ. ಏನ್ ಮಾಡ್ತಾರೆ ಪಾಪ 4 ದಿನ ಸುಮ್ಮನೆ ಆಗ್ಬಿಡ್ತಾರೆ. ಓದಿ.
I'm pressing the wife of that sister, my lord. There were 10 people.
They have not seen. ಸತ್ತ ಮೇಲೆ ಗೊತ್ತಾಗಿದೆ. ಮೊದ್ಲೇ ಗೊತ್ತಾಗ ನಿನಗೆ ತಿಥಿ ಮಾಡ್ಬೋದು ಹೇಳ್ಕೊಂಡು. ಓದಿ PW13 ಓದಿ.
But another important issue, not the Karnataka notice. Whose was at the house when
All right.
visited this court, and accused was arrested from the house. But if I have police ಬಂದಿದ್ದು 10 ಗಂಟೆಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. 10 ಗಂಟೆವರೆಗೂ ನನಗೆ ಇಟ್ಕೊಂಡು ಇರ್ತಾರೆ ಸ್ವಾಮಿ.
Don't ask questions to the court. We are not answerable to anybody. Can only assist the court. ನಮಗೇನು ಗೊತ್ತಿದ್ಯಾ? ನಿಮಗ್ ಗೊತ್ತಿರ್ಬೋದು ಸ್ವಲ್ಪ ಕೌನ್ಸಿಲ್ ಆಗಿ. ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಏನಾಗಿದೆ ಅಂತ. ನಿಮ್ಗೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಏನೇನು ಮಾಡಿದೀವಿ ಅಂತ. ಅದೆಲ್ಲ ಇಟ್ಕೊಂಡು ಆಮೇಲೆ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡೋದು.
ನೆಕ್ಸ್ಟ್ ಡೇ ಮಾಡ್ತಾರೆ.
Merits, sir. Technicality only on merits, not now. Mama. The husband filed the present application for suspension of sentence dated 9/12/2021 and released on bail, mainly contending that the prosecution has not at all proved its case beyond reasonable doubt. There was no harassment of dowry soon before death of the deceased, which is not established in evidence. Therefore, it cannot be said that only on account of the said harassment deceased died. It further contended that there is no evidence in order that any cruel harassment or in connection with the demand dowry. Therefore, the trial court erred in holding that there was a demand of dowry harassment from the appellant. As a matter of fact, the statement recorded in Section 313 CRPC for PW1, there was no question framed or any incriminating circumstance put to the accused, either regarding harassment or cruelty or dowry. Further content that, as to be seen from the statement of witness recorded in Section 161 subclass 3, none of the witnesses never stated anything as to how the deceased mother died. None of the witnesses have seen or viewed the fact the accused was killed, his wife, by throttling her neck, which being the case, the trial court has completely erred in wrong in wrongly convicting the accused Section 302 IPC. He further contended the accused the conviction of the appellant for the offense punishable on the parts of 302 IPC absolutely incorrect, and conviction is no basis and no evidence. The deceased died of not homicide death, but which is very much evident from the admission of PW1 with our examination dated T3/2021, where he has admitted PW1 viewed through window that his daughter in hanging position. Thereafter, the accused removed his daughter hanging inside the room and laid her body on the floor of the house. Such being the category of admission of PW1, the trial court proceeded to convict the accused on wrong notion, which cannot be sustained. Stop. It is further contended that the deceased not died due to homicidal death, as is the evidence from PW10. The medical official who conducted postmortem report admitted that he has not seen compression on neck due to strangulation and not noticed bruising present, BRUISC present, and also not seen swelling tissue. There were no nail marks over the neck. It is further contended that the entire episode of recovery of material objects number 1, 2, 3, broken bangle pieces, 2 shirt buttons, shirt which is alleged to have been worn by the appellant at the time of alleged commission of crime is fabricated, created by the prosecution in order to fix the appellant falsely in a false case. Absolutely, there is no material against the accused. Homicide death of deceased, therefore sought to allow the application. Whether you are on bail during the pendency, sought allow application. Stop. We have heard the learned counsel for the parties list. Sri Ismail, Sheikh Ismail, learned counsel for the appellant, contended with vehemence that absolutely there is no material to prove it is homicide death. It may be a suicide death on the basis of allegations of the prosecution witnesses. So PW1 is the complainant and father of the deceased has deposed that he has seen the dead body through window was hanging and the accused was outside the house and he has removed it is further contended that When he went near the house, at that time accused told him that his daughter was in a room by bolting the door inside. I viewed through the window that my daughter was hanging first. Thereafter, accused removed my daughter hanging inside the room and laid her on the floor of the house. So he would further contended that PW10 daughter not notice any strangulation marks nor uresis. Thereby, the trial court proceeded to convict the accused only on the basis of the presumption assumption, and there is no direct evidence against the accused. To stop, he would further contended that the evidence of PW3 and 4 cannot be considered at this stage. They are trusted witnesses. PM report also does not depict the strangulation marks. Therefore, he sought to allow the appeal. Stop. For contra, Sri Majge, learned counsel for the state, while sustaining the order for sustaining the input judgment conviction passed by trial court, contended that while producing the documents along with the present appeal, the appellant has not produced the evidence of PW3 and 4. He brought to the notice of the court through records the evidence of PW3, wherein sister of the deceased, wherein they have specifically stated that on 10/5/2010, 2020 at 4 p.m., accused came to their house. At that time, CW3, CW10, Surendra, and herself were in their house. At that time, the accused made galata with his wife. When they asked as to why he would make galata, the accused replied as to why they were intervening their personal life. CW3 carried the baby of Madhura and came out of the room. Sitting outside the room, we heard noise. They heard noise from the inside the room. After some time, noise inside the room was stopped. When the PW3 and others insisted to open the door of the room, but it was not open. They called neighbors CW8 Venu, CW12 Anand. They came and opened the door by breaking. When they went inside, saw the accused keeping his hands on the neck of her sister. Physically checked, confirmed that sister was no more, and saw the marks of assault on cheeks of our sister. He further invited the attention of the court that PW4 reports that one day in 2020, the accused came to the house of PW1, asked the inmates to go out of the house and bolted the door of the room from inside, and murdered Madhura by strangling for not having fulfilled his additional demand of dowry. He went inside, saw the dead body and injuries on right arm and face of Madhura. He saw finger marks on the neck of Madhura. He would further contended that the PM report, Exhibit P10, clearly depicts there is a PM report. Indicator mark seen on the center of neck measuring 8 to 2 cm. He would further contended that there is a prima facie case against the accused who was inside the room along with the wife on the date of the incident. He has not whispered anything in 313 statement recorded, and they are not offered any expression. Therefore, it is a fit case to reject the bail application, suspension bail application. Therefore, shall reject the application. Next one. Having heard the learned counsel for the party, it is undisputed fact. The trial court, considering both oral and documentary evidence on record, has recorded a finding that the death of the deceased was homicidal death, and further proved that there was a constant demand of dowry from the accused. On 10/5/2020 at about 4 p.m. in the house of CW1 at Vasudha village, the accused was subjected by mother of cruelty soon before her death. Further recorded a finding that the accused, with the intention, commotion with his wife Madhura in her parents' house for not fulfilling additional demand. With intention and knowledge, caused death, pressed her neck by force by means of his hands, thereby caused the murder. According to the session judge, then it is accused. First of though the learned counsel for the appellant contended with vehemence that PW1 complaint not support case of the prosecution. The learned session judge ignored the evidence of PW1 who is the complainant and proceeded to convict the accused based on the other evidence. The fact remains PW 3 and 4 in the categorical terms stated on board that ನೀವು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರ್ದಪ್ಪ ಆಮೇಲೆ ಏನ್ ಬೇಕು ಹೇಳಿ that on 10/5/2020 at 4 p.m. accused came to their house. At that time CW3 10 Surendra and the PW3 were present. When they asked why you are making galata in the house, Surendra myself was present in the house. At that time the accused made galata with his wife. When they asked, he accused replied as to why they are interviewing their personal life. Thereby, accused number CW3 carried the baby at Madhura, came out of the room, sitting outside the room. When they heard noise from the inside, after some time, noise inside room was stopped. When insisted to open the door of the room, but it was not open, they called neighbor CW8, Venu, CW12 Anand, who opened the door by breaking. When PW3 and others went inside, saw the accused keeping his hands on the neck of her sister and physically checked, confirmed that her sister was no more. The presence of accused number 4 was spoken to by PW3 and 4 in the categorical terms. Though correspondence was made to PW3, he denied his suggestion that it is false that he never made any galata with his wife. It is false that 10/5/2020 accused has not visited house. It is false that the accused is not responsible death of her sister. It is false that her sister died due to some other reason. It is false that I am deposing falsely against the accused. It is false that the dowry was being not given. It is false that dowry was being given to the accused in the form of gold ornament, cash deposed by her. It is false that the accused loved and married sister and was happily with his wife. So the doctor who conducted PM report of the issued exhibit P15 PM report specifically stated on vote that ligature marks seen on center of neck measuring 8 cm into 2 cm extending from 5 cm below right part articles region, 5 cm below left Achilles region. It is not seen back neck due to age. Skin online ligature mark crash hemorrhagic spots seen on cutting, bleeding present. So, though the learned counsel for the accused pointed out that in the cross-examination, the PW 10 has admitted that they have not seen the compression on neck due to strangulation, has not noticed bruises present, not seen swelling issue. There was no nail marks over the neck. The fact remains that the accused died homicide death is not in dispute, though it is stated that his suicidal death not been proved by producing any contra material, nor adduced any separate defense, or stated in even the statement except denying all the incriminating circumstances in toto by the accused. First up, the accused died, the deceased died 2 years after giving a birth to a child within 7 years. And it is duty of the husband to protect the wife. When the evidence or record clearly depicts he was inside the room along with the wife, he has not discharged the burden. What happened to the wife? How his wife died? In the clause of 106 of the Evidence Act. There is a prima facie case made out by the prosecution on conviction. It is well settled that in case of post-conviction, bail by suspension operation sentence, if there is a finding of guilt, the Honorable Supreme Court time and again held that the question of presumption of innocence does not arise, nor is the principle of bail being the rule and jail is except in the fact once there is a conviction upon trial. The court considering an application for suspension sentence, a grant of bail, has to consider prima facie the merits of the appeal, coupled with the factors. There should be a strong compelling reason for grant of bail, notwithstanding an order of conviction, a suspension sentence, and strong compelling reasons must be recorded in the order grant of bail as mandated section 389 CRPC. It is well settled that this court, while considering the application, should exercise discretion in a judicious manner and not as a matter of course. Though at the stage of considering the application, a detailed examination of evidence and elaboration of document on merits of the case need not be undertaken. There is a need to indicate such orders reasons prima facie case, concluding the while bail was being granted, particularly where accused is charged having committed serious offense. In the admitted in the presence case, death of the deceased is homicide death, and which is the wife of the accused has not discharged. How she died when he was present along with her in the room as spoken to PW 3 and 4 categorical terms. In view of the above, the accused has not made out any ground to consider the application at this stage, consider the application for suspension sentence and this on bail. Above, IA 1/2022 for suspension sentence and this bail is rejected to have merit. Always, any orders on the pass on IA never come to the merit, sir. Yes, Rajan. Yes, objection shall raise. According. Excuse number 2. Yes, Rajendra. This is A2. SC ಇದೆ ಅವ್ರಿಗೆ ಇಟ್ಕೊಳ್ಬೇಕಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅನ್ಸುತ್ತಲ್ಲ ಅಕ್ಯೂಟೆಡ್ ಎಸ್ What the motive for murder?
Accused number 1 with accused number 4. Illicit relationship.
What is the relationship between the deceased and accused 1 and 2? Oh. You have killed your wife, husband. Accused number 1, 3 and 4. All right.
Have the law is that A1 gets time like that, A3 tab and A4 hereafter A1, A3, A4 this kind of requirement and
What happened to A1? Was no appeal is filed? Yes.
all
So what is the vote tax against accused number 2? She is the wife of the deceased.
all the material aspects except 3 and 4.
Yes.
This is the other.
PW3, the daughter of the deceased. The daughter of the accused number 2 or the deceased? Okay. What is the age of the PW3? 17 years. ಗೊತ್ತಿರುತ್ತೆ ಎಲ್ಲ ಅವಳಿಗೆ.
Except that evidence, no other evidence available. All other evidence are lost.
Only based on the PW3. Number 2 convicted.
Now.
No, Mr. Majge, whether the trial court convicted the accused number 2 only based on PW3 evidence. No, she is 17 years girl. She can object. ಯಾರ್ರೀ ಬಾಡಿಗೆದವ್ರನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾವ. No, what the doctor evidence says? By whom? ಎಲ್ಲಿದೆ? Accused number 1, whether PWC says she is the eyewitness to the incident, both accused number 1 and 2 strangulated her father. Elide torsi. Yes, please. The accused number 2 open the door ಇರ್ಬೇಕು. No, being the daughter of the accused and the accused number 2 and deceased, 17 years, was studying PUC. She could have reacted. At what time? 10:30 p.m. She should have. No, this is in the village, Tane. Rural Tane. She could have cried, screamed. ಗಲಾಟ ಮಾಡಬಹುದಾಗಿತ್ತು. ಅಪ್ಪನ್ನು ಸಾಯಿಸ್ತಾ ಇದಾರೆ, ಬನ್ನಿ ಬನ್ನಿ ಕೂಗ್ಬೇಕು ಅಕ್ಕ ಪಕ್ಕದಲ್ಲಿ. He is not a child, sir. 17 years. Son, minor, all right, up to 20 years minor. ಇವಾಗ ನೀವು SL ಶೂಟಿಂಗ್ ಮಾತಾಡಿ, ಹೊಡಿತಾರೆ ರಿವರ್ಸ್. No, what prevented her? Rise alarm. ನಮ್ಮ ಅಪ್ಪನ ಸಾಯಿಸ್ತಾ ಇದಾರೆ, ಬನ್ನಿ ಅಂದ್ರೆ ಓಡ್ ಬಂದ್ರು ಅಕ್ಕ ಪಕ್ಕ ಮನೆಯವರೆಲ್ಲ. She is the complainant. All right, accused number ಆಮೇಲೆ ನೋಡೋಣ. We are not concerned with relationship. Concern only murder. Common charge. 3 and 4 acquitted. They are supported 1 to 4. ಅವರು ಬಾಡಿಯ ಇದು ಡಿಪಾಸಿಟ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಡಿಪಾಸಿಟ್ ಅಮೌಂಟ್ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಕೊಂಡ್ಬಿಟ್ಟ. Whether she was on bail, ಇವಳು ಆಚೆ ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. If ultimately you convicted on merits, you can't help it. She was on bail. Being a lady.
This lady. ಮೂವತ್ತಾರು ವರ್ಷ. ಎರಡ್ ಎಂಟಕ್ಕೆ 36 ವರ್ಷ. 18 ಮತ್ತು 4 ವರ್ಷ
ಆಗಿದೆ ಅವಳು.
And the Court of Karnataka and there we have tried to an accident and denied an accident.
About 50 years. She was on bail. That's her. And she is the only witness. We will decide on merits PW3 whether her own evidence can be convicted. What prevented her to alarm? Illicit relations may be true. ಅವ್ರ ಮನೆಗೆ ಬಂದು ಅವ್ರ ಮನೆಯಲ್ಲೇ ಇದ್ ಮಾಡುದು. They were there in the rented house. ಓನರ್ ಮನೆ. ಇವಾಗ ಈ ಮನೆಯಲ್ಲಿ ಇದ್ದಿದ್ದವರು
ಬೇರೆ ಮನೆ.
ಅಲ್ಲೂ ಮುಂದುವರ್ಸಿದ್ದಾರೆ ಅವ್ರ ವ್ಯವಹಾರ. Oh, she is our giant alarm's father.
ಕಮಿಷನ್ ಕೊಡಬಾರ್ದು ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
ಅಲ್ಲ ರೀ, ಅವಳು ಸಣ್ಣ ವಯಸ್ಸು 7-8 ವರ್ಷ ಮಗು ಎದ್ಕೊಂಡ್ಬಿಡುತ್ತೆ ಅಂತ. 17 ವರ್ಷ. Know the world affair. She can stop these people. She can say stop the way on the support father. She should have just alarm adjoining ಅಕ್ಕಪಕ್ಕ ಮನೆ. ಏನೋ ತೋಟದಲ್ಲಾಗಿದ್ದ ಪರವಾಗಿಲ್ಲ. ಯಾರ ಅಪ್ಪನ ಸಾಯ್ತಾರೆ ಬಂದು ಕೂಗ್ಬಿಡೋರು ಹೋಗೋಳು. ಕರೆಕ್ಟ್ ರೀ, ಕೂಗಿದ್ರೆ ಆಗುತ್ತಲ್ಲ, ಕಿಚ್ಚು ಬಿಟ್ಟಿದ್ರೆ ಆಗುತ್ತಲ್ಲ ಜೋರಾಗಿ. ಇಸ್ ನಾಟ್ ದೇರ್ ಕೇಸ್. ಅವಳನ್ನ ಒಳಗಡೆ ಹಾಕಿದ್ರು ಅಂತ. You are not disputing she is eyewitness to the incident. Where? Whether you have stated, you cross-examined her. Grounds ಇರ್ಲಿ, grounds ಇರ್ಲಿ, cross-examine ಏನ್ ಹೇಳಿದಿರಿ?
There are 6 of the judgment.
She was present all along the next day morning. But
ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಯಾವತ್ತು?
next day 17/11 about 11 a.m. my brother of the deceased.
Why she should have lodged the complaint? ಅವ್ರು ಹಾಕ್ಬಾರ್ದ ಕಂಪ್ಲೇಂಟ್?
She was present at the spot at 11 a.m.
Should have lodged the complaint.
Before lodging the
Morning.
ಒಂದು ತಿಂಗಳಾದ್ಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್ Yes, ma'am. The patent application is filed by the accused number 2 by province of section 3891 CRPC for suspension sentence release on bail. Mainly on the ground. ಏನು ಹೇಳಲ್ಲ ರೀ ನಿಮ್ಮ ಇದರಲ್ಲಿ mainly on the ground. But PW3, the daughter of the deceased and accused number 2 has been projected and examined as eyewitness to incident. None of the witnesses has spoken to friends or presence in the house at the time of incident. According to the prosecution, the incident took place on 16/11/2007, 10:30 p.m. But she was not disclosed the incident to anyone until the statement was recorded by the police on 14/2/2007. 14/2 not 12 re. I think re. Huh?
I was
correct.
14/12/2007. Despite her presence at the spot about 10 a.m. on yesterday and also hospital. Thereafter, police were present and she has been to Chikkajala police station at about 10:30 to 11 p.m. along PW1. It is not her case that the accused created fear and she left frightened. She did not come forward, did not show up time till recording her statement. The behavior and conduct of PW3 immediately after incident cast serious doubt regarding her presence at the time of incident. Being the daughter of the deceased and the accused number 2 age was 17 years, studying in college, having only knowledge after seeing the incident, had not raised any alarm to attract the neighbors and did not disclose anything about the incident to her neighbors, relatives, or present in the locality. The accused number 2 was released on bail during the pendency of the trial and she has not violated any conditions imposed by the trial court. And the appellant has got very weakness on merits. She will likely to succeed. If the application is not allowed, the application is allowed, no hardship cost to the other side is not allowed. She will put to 8 hardship as she is now age about 50 years. And she is the only earning member in the family. Therefore, sought to allow the application. The Learned Counsel for the State, while justifying the input judgment of conviction out of sentence, contend that PW2, PW3, who is the eyewitness to the incident, has deposed that accused number 1 and 2 tied a cloth around the neck of the deceased and pulled it, thereby strangulated the deceased. At that time, accused number 3 had tightly held the head of the deceased, and accused number 4 kicked the deceased and twisted him, and accused number 3 stabbed on the backside of the deceased with a knife, thus intentionally caused death. Accused number 1, 2, 3, 4, not being the members of scheduled caste, committed the murder of the deceased, member of scheduled caste. Thereby, the trial court rightly convicted the accused. Though accused 2 was granted bail during a plea trial, it is not a ground to grant bail in a post conviction when there is a pending against accused number 3. Accused number 2, therefore, is sought to reject the application. Having heard the learned counsel for the parties. It is undisputed fact. The accused 1 and 2 convicted by the learned session judge under the provisions of section 302, only 302, 302 and 201, 34 IPC, and accused number 3 and 4 acquitted. You are not filed in appeal. Accused number 3 and 4 acquitted. And state has not filed in appeal against the acquittal of the accused number 3 and 4, though a common charge was framed as not filed in appeal as on today, though a common charge was framed. Stop. The entire case of the prosecution is that the PW3 was the eyewitness to the incident on the date of the unfortunate incident occurred. According to the prosecution, the accused number 1 and 2 tied a cloth around the neck of the deceased and pulled it, thereby strangulated. If that is so, the PW3, who is the not only daughter of the deceased and daughter of the accused number 2, would have raised the alarm in order to protect the father, as he was aged about 17 years, studying in a college, having holy knowledge. Huh?
17.
All right, 15 years. SL ಆಗ್ಬೇಕು 16 ಆಗ್ಬೇಕ್ರಿ. years. 17 years. It is also not in dispute. The brother of the deceased lodged a complaint immediately next day of the incident. Unfortunately, the statement of PW3 recorded after 1 month, that is on 14/12/2007. The accused, the prosecution witnesses are not, any of the prosecution witnesses are not whispered about presence at the time of the incident occurred, at the instance of accused number 1 and 2. Stop. In view of if she was really was present at the time of the incident, what prevented her to inform the neighbors immediately, not on the day, at least next day morning? The same is not forthcoming. Therefore, the presence of the accused number PW3 being daughter of the deceased and accused number 2 is doubtful on that day. It is also not in dispute during the pendency of the proceedings before the trial court. The accused number 2, who was released on bail, she has not violated any terms or conditions. As on the date of the incident, 2008, she was aged about 36 years. Now, as on today, she is aged about more than 50 years. And being a lady, considering the peculiar facts of the present case, we have a considered opinion. She is entitled to the bail. Enough the above, we for the following order. IA 1/2022, a suspended sentence, these are bail with accused number 2 is allowed, subject to following conditions. 1 lakh. What is the fine amount imposed? To pay fine amount 10,000 and should not leave the jurisdiction of the court without prior permission of the session court. Yes. 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 All right, pass on. ಮೂರು ಅದನ್ನ ಎಸ್ ಧನಂಜಯ ಕುಮಾರ್, ಮಲ್ಲನಗೌಡ. All right, yes. Yes, we are ready, Mr. Madhukar, Mr. Agde. This, the only point is, one the Honorable Leonard just says, it is only BCC got power. The other justice is only court. Yes. Order. And based on the earlier order, you filed an application for recalling by a subsequent judge. Checked it, the application and held it to the court, not the BCC. No, the reference is who is the authority? That's all. Court or DCC? Percy. DCC drug disposal committee na? The provisions invoked are Central Act or State Act? We are not on the many cases, only this case. Then you say, can't mix up. Only the way the offense under the State Act attracts one state. Can't fix. All right. Kodri.
Central Act.
Your delegated powers. Yes, who pays for this? Yes.
Number 5. 5. 6.
Yes, you are paying for whom, Mr. Who pays for the first case? What is this case? Gopal. This case, sir. Who is Gopal? Then we will delete this. Deshpande. Then, sir, jobs are better. Or Madidivi and reference matter. We'll delete that. Don't come, we can't wait for anybody. Delete.
Objections.
Objections come from Adala. Court ko baradala. What to do? Sala pass out. Delete. Yes, come on. What is your matter? Kodi.
And the respective submission would be my words.
You are applying 6.2. You and Deshpande is same.
All same melodies. In fact, all these matters pertain to the same point on reference melodies. Whether is it the DDC, which has powers under 52A of the NDPS Act, or whether it would be the courts under 451 of the CRPC. This would be the point of reference melodies. If I also kindly have melodies, in fact, I have kept 3 spiral bounds melodies, of which spiral bounds.
All senior counsel don't give all spiral. Just give small things.
Kerala High Court on a reference and held that DDS has the power melodies. DDC has the power.
ಏನಾಗಿದೆ ಅಂದ್ರೆ what mistake us ಸಿಗ್ನಲ್ ಸೈಡ್ ಅಂದ್ರೆ ಇಷ್ಟು ದಪ್ಪ ಬುಕ್ಗಳು ಮಾಡಿ ಇಷ್ಟು ದಪ್ಪ ಎವಿಡೆನ್ಸ್ ಹಾಕಿ ಲಾಸ್ಟ್ ಎಲ್ಲ ಓದಿದ್ರೆ ಏನಿರಲ್ಲ ಯಾವ್ದು ಒಂದೇ ಒಂದು ಅಷ್ಟೇ. ಎಸ್ ಕೊಡಪ್ಪ.
My intake was that we give us the exact reference to it. Not a very voluminous book, give us this small book one.
No, we don't upload of wellness of book.
And I try to keep it as.
Now today's paper. Yes. Brief judgment should be brief, not elaborate.
how they used to do it, well, 4 pages, 5 pages, how they did just of everything.
ಅವರು ನಮಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸಣ್ಣ ಬರಿಬೇಕು ಅನ್ನೋ ಬದಲು ಲಾರ್ಜ್ ಹೇಳ್ಬೇಕು, ಸ್ವಲ್ಪ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೇಕು.
Yes, my lord, but each sentence has a lot of meaning. My lord, my lord, in the index, my lord, you notice, rule numbers 1 to 10. The first one is judgments leading to the present reference.
All right.
There are 4 decisions that is basically present reference, which I will point out. 2 is, my lord, point for consideration in the present reference. 3, my lord, relevant definitions for consideration of the present reference. There are 5 definitions of importance, my lords. The usage of the word custody, disposal, destruction, confiscation, and conveyance. I will point it out, my lords, where they all figure. 4 is object and scope of section 451 of the CRPC, my lords, mainly dealing with interim custody of vehicles. 5, my lords, procedure to be followed under section 451. The leading case is Sundarbai, Ambalbai, Desai, my lords, which we always follow when we seek for an interim custody. Well, 6 important sections under the NDPS Act, how this controversy arose between the 2 enactments. 7, my lords, section 52A and the notifications under it, there were 3 notifications, my lords. One was in 1989, followed by 2007, then by 2015. The notifications would be important. The whole emphasis would be notification was for disposal of drugs, my lords, not for interim custody of vehicles. My lords, 8 decision in Mohanlal's case. Now, this is a judgment, my lords, which has kind of created a lot of confusion.
You mean to say the notification under section 52A only for drug disposal?
For disposal and destruction, those 2 words, my lords,
Correct.
not for the purpose of custody. I will point that out.
Correct.
And when it comes to confiscation, my lords, we have section 60 and 63 of the NDPS Act. So the words make it very important, my lords, where the word custody has been used. So, my lords, 8 is the decision in Mohanlal's case, 2016, my lords, which has led to a slight confusion of the understanding of the Act.
Where is that?
My lords, Mohanlal's case is in my second book, but I have just mentioned it that I will deal with it, my lords. I didn't want to make this very original. The citations are put in separately, my lords. I will point it out. And, my lords, 9 is judgments of various high courts, my lords. Now we have as many as 21 decisions, my lords, with 451 CRPC is applicable, against which we have 3 decisions, my lords, which says DDC has power. Of these 3 decisions, 2 is of Kerala, 1 on reference, 1 subsequently followed, and 1 of our High Court, my lords, which is point of reference now. 3 decisions which hold 52A to go before Drugs Disposal Committee, whereas 21 decisions which say 451 CRPC. And, my lords, 10, I made a conclusion, 7 conclusions that we have drawn after reading through all these decisions. This is for the purpose of convenience. Now, my lords, may kindly notice page 1. The judgments leading to the present reference. My lords, the first judgment.
One minute. Whether the provisions of section of the CRPC is applicable to NDPS Act?
Yes. There's section 36 and section 51, which makes it applicable. So we'll have to again go back to section 4 and 5 of CRPC, where it is not covered specifically under a specific act. The provisions of CRPC are applicable. And 36 and 51 makes it clear. I will point that aspect out also when I deal with the provisions of NDPS Act.
What is mean by destruction and disposal of what?
Of drugs. When you say destruction and disposal, as I point out.
No, this 52A NDPS Act,
Yes.
it refers to only drugs or vehicle also.
No, my lords, the usage of words there is drugs, psychotropic substances, controlled substances, and conveyances. Now, when we come to conveyances, my lords, when it comes to the aspect of disposal and destruction, that will be in the end post confiscation proceedings. If you have to destroy anything or dispose anything, it will not deal with interim custody of conveyances as the endeavor will be that.
Now, according to you, 451 is the CRPC is the provision to release the vehicles.
For interim custody. That's the only provision, and that has to be read into it as read by various courts, my lords. That is the manner in which we will have to look at 451. My lords, may kindly take page 1, my lords, of the same before decisions, my lords. Sri Mahashakti Roadways was the state of Karnataka. His lordship, my lords, would take in view that 451 CRPC is maintainable seeking interim custody of vehicles. My lords, then comes Zoom Car India Private Limited, an order dated 12/11/2020, where the court held 451 is maintainable and would release the vehicle. Then comes Zubaida. This is where, my lords, a contra view was taken. Zubaida was the state of intelligence officer, and this was on 24/11/2020, just about 12 days after the previous order, my lords. Now, once the view taken in this case was DDC has a power, what the state would do is they would file an application in Zoom cars to recall that order, which my lords would get
Rejected.
serial number 4. And there, my lords, the court would differ with the view taken in Zubaida and would say court has a power, and this is a matter which has to be referred to a larger bench. My lords would get serial number 4. Then, my lords, on the next page, page 2, NDPS Swami was the state of Karnataka. Again, the court took a view, there are contradictory judgments, and therefore this matter has to be referred to the larger bench. Now, these are the 5 decisions, my lords. I will just pause here for a while, my lords. I will point out the decisions which is in book 2, my lords. These 5.
No, instead of first decisions,
Yes.
you go to statutory provision first.
My lords, please. My
To
lords,
satisfy the court on statutory provision, then
I will do that. My lords, page 3 and point for consideration which I have concisely put, my lords.
Yes.
Whether the power jurisdiction to consider interim custody of conveyance/vehicles is to be traced to the magistrate court or special court under section 451 CRPC, or whether such powers are conferred on the drug disposal committee constituted under the notification issued by the central government. My lords were pleased to ask who has the power. It's the central government under 52A that has this power. Under section 52A of the NDPS Act, my lords, please notice page 4, my lords, the definitions.
Yes.
My lords, custody, when we talk about custody, my lords.
This is from which act?
Custody, my lords, page 4, bracketally as seen under section 451 under NDPS. That's the only place where we get custody. My lords, this is CRPC. 451. Chapter 451 to 459 are all the beloved sections, my lords, when it comes to property, my lords. 451. 451.
No, where the definition of custody?
Definition of custody and particular usage of the word custody. We not get it under 52A. My lords may see when any property is produced before any criminal court during an inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property. My lords may notice the word custody. My lords may also notice 457 for a minute, my lords.
457.
Here, the difference between 451 and 457 would be, my lords, when there is a seizure and if the property is produced before the court, then 451. If there is seizure, my lord, seizure is reported but the property is not produced before the court, then 457 will be applicable. That's all is the difference between 451 and 457. 457 may be produced, my lord, they use the word custody. Procedure by police upon seizure of property. Whenever the seizure of property by a police officer is reported to the magistrate under the provisions of this code, and such property is not produced before a criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit, respecting the disposal of the property or the delivery of such property to the person entitled to the possession thereof, or if such person cannot be ascertained, respecting custody and production of such property. Custody is used here. The only difference is that if the property is produced before the court, we file an application under 451. If property is not produced, we file it under 457. This is the only. So my lords, the first definition that I put is of custody in page 4 of my synopsis.
Yes.
One. My lords may now notice the second definition that I have pointed out there is disposal. Now this word disposal, my lords, we get it under section 52A of the NDPS Act. Disposal is, my lords, getting rid of something. That's the definition of disposal. Now 52A of NDPS Act can be seen in terms of disposal.
Yeah.
My lords, this was inserted in 1989, my lords. 29/5/1989. Disposal of seized narcotic drugs and psychotropic substances. One, my lords, again, one may be noticed that it was substituted in 2014, my lords. 2014. By Act 16 of 2014. Now, what the difference was prior to the substitution, my lords, the usage of the word controlled substances or conveyance was not there earlier. But by the substitution, they brought in those two words, my lords. Controlled substances or conveyances. Now, may I read 52A1, my lords. The central government may, having regard to the hazardous nature, vulnerability to theft, substitution, constraint of proper storage space, or any other relevant consideration in respect of any narcotic drugs, psychotropic substances, controlled substance, or conveyances by notification in the official gazette specify such narcotic drugs, psychotropic substances, controlled substances, or conveyance, or class of narcotic drugs, class of so and so, or conveyance which shall, as soon as may be after the seizure, be disposed of. This is the most important word there. Be disposed of by such officer and in such manner as the government may, from time to time, determine after following the procedure herein after specified. Then they say, my lords, insofar as disposal of the drugs.
Yes.
Lots of notice is the disposal, how it has to be done. Now, all this has to be done by virtue of a notification by the central government, which will come up with this DDC, my lords. Now, my lords, in pursuance of 52A, there were 3 notifications issued by the central government. The first notification, my lords, was in 1989. In the 1989 notification, there was no usage of the word conveyance. But the second notification was 2007.
Wait, that.
There were 3 notifications that I produced. My lords could see in book 2, the last 3 of it. My lords.
First notification 1989.
1989. My lords, is at page 108.
Second notification
2007. notification 2015.
Yes.
I was saying kindly see the three notifications for the.
Only three as on today.
As on today. Well, what happens is one supersedes the other melons. That's how it works. So at present we have 2015 melons, but it is necessary for us to see the three notifications to know the constitution of the DDC and the purpose for which it was constituted. Melons at page 108 is its 89 notification. My lords may kindly take page 109. There's section 52A.
1 minute. Yes.
Page 109 in section 52A, as it stood before the substitution is extracted, my lords, the whole 52A. Then, my lords, comes the quarterly standing order 1 of 89. Thus, the standing order would read this, my lords, whereas the central government considers it necessary and expedite to determine the manner in which a narcotic drug or psychotropic substance, as specified in notification 4 of 89 dated 29 May 1989, which shall as soon as may be after the seizure be disposed of. Again, my lords, the words is be disposed of, having regard to the hazardous nature, vulnerability to theft, substitution, and constraints of proper storage space. Now, therefore, in exercise of powers conferred by subsection 1 of 52A of the NDPS Act, government hereby determines that the drugs specified in the aforesaid notification shall be disposed of in the following manner, namely, section 1, drugs meant for disposal. My lords may notice the drugs, narcotic drugs, and then the psychotropic substances for disposal. Then section 2, general procedure for sampling and storage. So what they would do is, my lords, when there is a large seizure of drug, you do the sampling and storage, which acts as primary evidence for later methods. Now they would sample and store. Section 2 deals with it. Next page, my lords, page 111. Section 111, receipt of drugs in go downs and procedure. Section 3, my lords will get that one. Section 3. Then section 4, at page 112, action to be taken by police and other empowered officers for pre-trial disposal.
Yes.
Then, my lords, section 5 at page 113, constitution and functions of the drug disposal committee. This is where it comes, my lords. This is how it is constituted. And they say how it's functioning, constitution functions meetings. And then 5.6, my lords, at page 114, the destruction of drugs.
Fine.
5.6 only, committee shall be empowered to order destruction of the seized drugs in following cases. My lords will get the names of the drugs and quantity,
Yes.
how it should be done. And below that, section 6 is miscellaneous, a certificate of destruction. Here are two words we get here. One is disposal, one is destruction. Now, why they use these two words is, my lords, when it comes to drugs and psychotropic substances, when you say disposal through auction, my lords, it is given to government companies or it could be given to drug manufacturing companies. They have to come in auction and take it. That is disposing it. Destruction is, my lords, they put it into huge incubators, burn it up. That is how destruction comes. So only the usage is disposal and destruction, my lords. Following this, page 116 is this notification of 2007. My lords, in 89, they have not used the word conveyance because it was never there in the act itself that came out of the substitution. So using the word conveyance is not there in 89. In 2007, my lords, again, we won't get the use of the word conveyance.
Yes.
The 2007 ಅಲ್ಲಿ ಕೂಡ at page 164.1 may be noticed, my lords, drugs disposal committee. Now this notification supersedes 89, but then drugs disposal committee 4.1. Again, they recognize drugs disposal committee. Functions are spelled out there. And on the next page, page 117, 4.2 mode of disposal of drugs in the watermelon. And then, my lords, page 118, annexure.
Now show us from the NDPS Act, other than 451 CRPC, to the specific provision, release the vehicles, not dispose of the drugs.
Cannot consider.
Issue before us is how a release vehicles release by the court or by DCC.
Interim custody.
Where the power of release of interim custody under DCC, NDPS Act. Show your notifications. No, notifications. Then
Therefore, insufficiencies are there. The power is vested with the authority as a final law.
will come later, the court views are.
Interim order.
Mr. Ikkade,
That is the proposition.
Ikkade,
Therefore,
we are not going by the judgments. We want to statutory power. A basic ಬರ್ತೀವಿ, basic ಬಂದ್ಮೇಲೆ ಆಮೇಲೆ judgment ಬರ್ತೀವಿ. First ಬೇರೆ ಎಲ್ಲಿದೆ ನೋಡ್ಬೇಕು. If there is no root, judgments interpret ಮಾಡ್ತೀವಿ ಬಿಡಿ. Sir, judgments, perception of each judge will our own perceptions. Perception, there must be some basis. ಅದು ಬೇಕು.
ಇಲ್ಲ. There is no section which provides for
Under NDPS Act, only 451. 451.
analogous to 451 or 457, it is not there in
Correct. Then,
therefore, you cannot find it in
on what basis? No, on what basis you say it is only DCC is the authority?
I will come to that later. I will come to that
First
later.
ಬಂದ್ಬಿಡಿ later,
ಯಾಕೆ ಅಂತ ಕೇಳಿದ್ರೆ DCC has got the power for disposal of the property.
Whether DCC, no, we want to know, Mr. Akkade, whether by notification issued under the NDPS Act, section 52A1, when the statutory power, there is no statutory power, can you give by way of notification?
It is not there in the notification of law. It's not there.
Do you agree? Release of vehicle only 451.
Yes, no, I don't agree.
Then,
The second interim measure has not been contemplated. There
All
is a
right.
specific reason for that.
all right,
Reason is these vehicles shall not supposed to be used intermittently by the persons who are who is an accused. That is the intention. That is the reason there is a special.
No, ultimately, sir, ultimately, drugs is different. Suppose drugs immorally or contrary to the law, they shifted to vehicles. You see, don't leave the vehicle. Ultimately, on merits, whether entitled or not, whether punishment or not, there. Why the waste of the property vehicle?
Immediately, there are provisions, not immediately, that has to be disposed of and the amount has to be kept in.
We are not on merit, sir. Reference is only release of the vehicle, whether DCC power or court. That's all.
Final power that has been given. There is no interim power that is restricted to DDC.
I think it may be on par with MMDR Act also. We can take a bank guarantee and release the vehicle for interim custody. What is wrong in that?
No, the reason is this particular.
Do you mean to say, once is, Mr. Regre, do you mean to say, Mr. Regre, once you say, once they seize drugs along the vehicle, should not reach the vehicle forever?
No,
Vehicle has to vanish itself. Vehicle has to damage
Yes.
public property, sir. ಇಲ್ಲಿ ತೋರಿಸಿ ಫಸ್ಟ್ ನಿಮಗೆ ತೋರಿಸಿ ವೇರ್ ಇಸ್ ದಿ ಪವರ್ ಆಫ್ ನಿಮ್ ಪವರ್ ತೋರಿಸಿ let him argue. All right, let him complete. Let him complete. You are not come to the point. Yes, please. Yes.
On the next page, page 119, application for disposal of seized narcotic and psychotropic substances. This is the application to be done to the magistrate. And thereupon, my lords, the certificate issued by the magistrate dated page 120. And then, my lords, the certificate of destruction. Same in page 120 earlier. Certificate of destruction. This is the whole object, my lords.
No, your entire argument is this notification pertains to only drugs, not the vehicles.
It pertains to disposal and destruction of drugs and psychotropic substances.
All right.
It was in 2007.
And
Now I will come to the last notification methods, where how the word conveyance got used, because there is a substitution of 52A, where they brought in controlled substance and conveyance. The same thing they tried to extract in the notification, but the purpose is disposal and destruction. That purpose did not change. Now, please, my lords, I have produced it at page 121. But my lords,
121 Hindi.
my lords, Hindi could be the office could be the- I'm sorry, I Hindi, and after that English they tell me.
Yes.
Whole thing in English I will speak.
This is all 126 only.
ಅದು ಇಲ್ಲ madam, there's one question before that.
Sorry.
I just passed it on.
The fourth notification.
Third. 89, 2015. Now 2015 is what is now in existence. Now, please see what happened in this is.
This is dated
16 January 2015.
16 January. Yes.
And my lords, page 6 only from what has been given, that's English part of it of the notification methods. In January 2015. My lords, to notice here that the usage of the word controlled substance or conveyance has come into picture because of the substitution that took place to 52A.
Yes.
When using that, my lords, in the very first paragraph itself, the last sentence may be kindly noticed, my lords. I will read, my lords, I just read that the whole section. In exercise of powers of the 52A of NDPS Act, herein referred to as the Act, and in supersession of notification of 10th May 2007, except as respect things done or omitted to be done before such supersession, the central government, having regard to the hazardous nature, vulnerability, their substitution and constraint of proper storage space in respect of narcotic drugs, psychotropic, controlled substance or conveyances hereby specifies the narcotic drugs, psychotropic substances, controlled substances, and conveyances which shall.
What is mean by conveyances?
Vehicles, we take it as vehicles.
Yes.
After that, what is important is which shall, as soon as may be, after the seizure, be disposed of. My lords, again, notice this word disposed of. The officers who shall dispose them of and the manner of their disposal. Then, my lords, items to be disposed of, my lords would see, my lords, they use the same controlled substance and conveyance also they brought into it. And then the next page, manner of disposal.
Yes.
Virtually manner of disposal, my lords, similar to the previous notification, how you have to dispose it. Then the drugs disposal committee 5. Same as how it was earlier.
Someone substance is vehicle is not there in the list. Yes.
Vehicle, but destruction.
Only in the latest notification.
Destruction and disposal that comes
Understood.
after confiscation
Yes,
proceedings.
understood.
As I will point out in the scheme of the act.
Understood.
It doesn't come for interim custody. Interim custody, we have to fall back on 451. In the end of a matter, my lords, if the court feels after acquittal or conviction, there has to be a separate proceeding on
No, according to
Yes,
you,
Yes.
the word use conveyances. But there is no provision how it was disposed of.
Disposed of matra is what is covered under this notification, not on interim custody.
Correct.
Interim custody, we have to fall back on CRPs. This will be my endeavor, my lords. So that's why these notifications only deal with the words of disposal and destruction, and I will show you the scheme of the act.
It is on par with Wildlife Act, Forest Act, in MMDR Act, everything.
Forest Act.
Even in Excise Act also.
Forest Act is only by exception, which I point out.
Yes.
On Forest Act. But here it may be seen, my lords, here it is for disposal and destruction post the entire proceedings. My lords will notice it 8 power of the drugs disposal committee for disposal of seized items. Again, 8 disposal, and they put in what is to be disposed.
Yes.
Same, the columns, all the drugs. My lords, when the drugs are mentioned there, 9 only, how mode of disposal is important, my lords. These 3, my lords, 9 1 only, opium, morphine, codeine, and will be disposed of by transferring to the government opium and alkaloid works under the chief controller of factories. This is one way of disposal, my lords.
You want to dispose of drugs.
Disposal of drugs. Second one, narcotic drugs and psychotropic substances to the chief controller of factories. Third one again, my lords, chief controller of factories, narcotic drugs and psychotropic substances. Fourth one, such quantity of drugs, chief controller of factories. Fifth, narcotic drugs and psychotropic, and here they use this conveyance, my lords, we notice, shall be disposed of in the following manner. Now, when we talk about disposal, there also, my lords, by way of tender or auction, after the entire proceedings of confiscation is over. It is not dealing with the interim custody of a vehicle. And 5A, tender and auction, and that is what is pointed out. 5B, my lords, destroyed narcotic drugs, psychotropic substances, controlled substances seized in the
Yeah, you are reading.
5B, my lords, 5B. Page 8 only, my lords. Page 8 is 5, small b, my lords.
Narcotic drugs.
Narcotic drugs, psychotropic substances, and controlled substances, no conveyances, my lords, in the form of formulations and without proper labeling shall be destroyed. So here we get the word destroyed. Till then it was disposals, my lords, now destroyed. Then again C, that is by tender and auction, you dispose it. Kindly notice 6, my lords, in the bottom of the page again, my lords, bottom of the page. Narcotic drugs, psychotropic substances, controlled substances which have no legitimate medical or industrial use, or such quantity of seized items which is not found fit for such use or could not be sold shall be destroyed. What else? 7 also, my lords, how it is put into and burnt off, my lords. Incineration. destruction of the drug. 7. Then, my lords, 10. Intimation to head of department on destruction. That is certificate of destruction.
Yes.
So how the word conveyance came in here is only because of that substitution which took place to 52A. The intention is not, we can't say, my lords, a vehicle just carrying some drugs, you burn it off, you destroy it. It's not the intention. In the scheme of the Act, as I will point out, my lords, once there is going to be 41 onwards in procedure.
No, even if drugs confiscated wrongly is transporting, can take criminal action against you. Law. Or the vehicle may be permitted to the state government, permitted to the state government.
That is post confiscation. Intent. Interim measure, my lords. The idea was to save too much of drugs, my lords. Where do you store it? There's no place to store it. So they say you take samples, you take photographs, you keep it as primary evidence, destroy these drugs. You don't need to keep it. It's not a case of someone asking for those drugs, but you destroy those drugs. And since you have
No, your argument is you can't destroy the vehicle.
and it is admitted and it is found no drugs, vehicle as confiscation act. That's why, my lords, I just point out, my lords, the scheme of the Act itself, NDPS Act, how it has gone about. 36 may be seen, my lords, 36A, where they make CRPC applicable.
36A of NDPS.
NDPS Act. Two provisions of the NDPS Act I will point out, my lords.
Yes.
The constitution of the special court is under section 36, my lords. Under 36A, there is a difference, my lords, for offences which are less than 3 years. That is not tried with the special court. It will have to be tried by a magistrate, my lords. 36A, small a, my lords. After that, 36A, small a, all offences under this Act which are punishable with imprisonment for a term of more than 3 years shall be triable only by the special court. So for less than 3 years, my lords, it will be clear magistrate, my lords. And it becomes clearer with 36 subsection 5, where you deal with it in a summary manner. Five may also be noticed.
Yes.
Summary disposal when it's less than 3 years. So wherein magistrates can dispose of matters in a summary manner. Fine. Now, my lords, 36C, capital C, is the applicability of code to proceedings before the special court. This is where CRPC 36C. Save as otherwise provided in this Act, the provisions of the Code of Criminal Procedure shall apply to the proceedings before the special court, and for the purposes of the said provisions, the special court shall be deemed to be a court of sessions, and the person conducting the prosecution before the special court shall be deemed to be a public prosecutor. This is one place where we find our CRPC, wherever it is not covered under this Act. And as I will point out, 52A does not cover interim custody, so we go back to Code 51. Let's suppose this, my lords, may kindly notice chapter 5, the procedure, my lords, how this whole thing is initiated under the NDPS Act. Now, my lords, under the NDPS Act, my lords, initially, you have an authorized officer, my lords, who has 4 functions. My lords, he has the power to enter, search, seizure, arrest. These 4 functions, my lords, we get between section 41 till section 52. Now, once he completes those 4 functions, So once he completes those 4 functions, my lords, he will have to entrust the entire aspect to an investigating officer. Investigating officer comes post that. So initially, it's only an authorized officer who carries out these functions, my lords. And if my lords would kindly notice section 51, my lords. Authorized officers power. Provisions of the Code of Criminal Procedure 1973 to apply to warrants, arrests, searches, and seizures. But then comes the most relevant provision 52. Disposal of persons arrested and articles seized. And it is under 52, my lords, where 52A came in as an insertion in 1989. Against disposal.
Yes.
Well, section 53, this is where handing over of whatever that officer did, my lords, to the investigating officer, 53. So they contemplate 2 different officers, my lords. One who does only those 4 acts, and second under 53 is the investigating officer, my lords. From here, investigation begins, from 53 onwards. Lords, we notice 53, the central government, after consultation with the state government, may by notification published in the official gazette, invest an officer of the Department of Central Excise, Narcotics, Customs, Revenue Intelligence, or any other class of such officers with the power of an officer in charge of the police station for the investigation of the offences under this act. So 41 the 52 were some other officer, then 53 is handed over to the officer in charge of a police station or an officer notified here. He continues it, my lords.
Yes.
Then, my lords, may kindly notice. This is very relevant, my lords. Now, what happens under section 60? That deals with confiscation of goods used for concealing illegal drugs. Section 60 onwards. 60 is liability of illicit drugs, substances, plants, articles, and conveyances to confiscation. Now, my lords, post the trial, after the trial, my lords, section 60 on confiscation comes in.
Yes.
So once this confiscation proceedings begin under section 60, now irrespective of whether they are acquitted or convicted, the confiscation proceedings begin, my lords, till 63, my lords, 60 to 63. My lords, when we have to read conveyances into this, post 63, my lords, if they feel a particular conveyance needs to be either disposed or destroyed, then they can do.
Yes.
Because when it comes to drugs and psychotropic substances, my lords, when it comes to drugs and psychotropic substances, my lords, as I pointed out, by taking sampling and primary evidence, you can destroy this.
No, Mr. Chota, your entire argument is there are procedures for disposal of drugs in the NDPS Act. There is no provision for release of the interim custody of the vehicle except 451. You can't go anywhere. That is your substance of entire case.
Absolutely. Now, I will come to the case laws on this, my lords, how our court constitute this and how the other courts have constituted this. My lords, the whole aspect was of that Mohanlal's case, my lords. Because of Mohanlal's case, is some confusion that has arisen. My lords, when I'm dealing with the judgments, can you permit me First to point out the decision of the Supreme Court, my lords.
Is that
How 451 interim custody was being given. Well, book 2, we kindly use book 2. Lords, first I just point out the Supreme Court rulings. I take 61. This is 3 paragraphs going to the Supreme Court.
yes?
It's page 61. Ashok Kumar is the state of Bihar. Why the vehicle should not be kept but must be given for interim custody. Just in 4 paragraphs, they say that. Page 61.
This is 451.
451. 451. Now, the leading case on 451, which also included narcotic drugs, my lords, is the next judgment, which is Sundar by Ambalal Desai versus
Which
State
is
of
this
Gujarat.
paragraph? This
Ashok Kumar.
Ashok Kumar paragraph.
Ashok Kumar, my lord, would need to say under 451, custody of vehicles need not be kept but has to be handed over as interim custody only for that proposition.
Where that?
My lords, we do not think, second paragraph itself, we do not think
Paragraph
this is-
two. Yes, yes.
keep the vehicle in the compound of the court indefinitely, my lords will get that. And they say release it. My lords, the most important
The
judgment.
release
is-
of the vehicle subject to the disposal of the case.
Subjectively, and that is what had been followed, my lords.
Yes.
Page 62, 2002, NSCC 283, my lords. Sundar by Ambalal Desai versus State of Gujarat. Most important ruling would be this, my lords. And according to me, this holds the field even in so far as NDPS Act is concerned. This holds the field.
Yes, where
My
that?
lords, the Drugs Disposal Committee came into existence in 1989, my lords. 1989. This judgment was much after that.
CC.
Yes, my lords, Drug Disposal Committee existence in 1989. Also, kindly take page 65, para 4. It commences with extracting section 451. Page 65, paragraph 4. But after extracting section 451,
No, whether the court had an occasion to deal with the provisions of the NDPS.
the provisions of NDPS, my lords, 52A, no, they did. But my lords, they dealt with narcotic drugs and vehicles also.
89, though this is committee came into force 89. The judgment 2002,
Yes,
there was no occasion for the Honorable Supreme Court to consider these provisions.
I will just point it out, my lords, on narcotic drugs and vehicles specifically, they say. in this.
Where that?
My lords, before that, page 66 only, section, para 5, section 451 clearly empowers the court to pass appropriate orders with regard to such properties. My lords will get that, my lords. 1, 2, 3.
Yes,
And at para 7, what purpose for which it is done, my lords? Why do you have to release the vehicles is in para 7?
yes.
And para 10, my lords, is how the court views what you have to do with various properties. Para 10, page 67.
Yes.
My lords may notice to avoid such a situation in our view, power under section 451.
It only says valuable articles and current notes.
First one, valuable articles currency note. Please come to page 68. After paragraph 14, vehicles, and also get that.
Para?
Yes, after paragraph 14, it is the vehicles.
Ah.
Vehicles, please see this, my lords.
Yes.
They say if it is unintended, vehicles become junk day by day. It is this contention, appropriate directions. And this is how the vehicles are dealt with under this judgment. Paragraph 19 is about seized liquor, my lords. Paragraph 19. Next page,
Read this vehicles.
please. My lords, the
Para 15.
Yes, the learned appearing for the state of Gujarat further submitted that at present in the police station premises, a number of vehicles are kept unattended and vehicles become junk day by day. It is his content and appropriate direction to be given to the magistrates who are dealing with such questions to hand over such vehicles to their owners or to the person that vehicles are seized by taking appropriate bond and guarantee for the return of said vehicles if required by the court at any point of time. However, the rest of the appearing petitioner submitted this question of handing over vehicle to the person from whom it is seized or to its true owner is always a matter of litigation, and lot of arguments are advanced by persons concerned. In our view, whatever be the situation, it is of no use to keep such vehicles, seized vehicles at the police stations for a long period. It is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of said vehicles if required at any point of time.
Magistrate or court?
Magistrate.
Or court?
Yes, Professor. In our case, it will be
It is beyond the value, beyond. It's to court.
special court more than 3 years as well, because special court acts both as a sessions judge as well as original jurisdiction of a magistrate. He can give complaint directly to the special court. That's how it works under the NDPS Act.
Yes, yes.
My lords, on the next page, page 19 deals with seized liquor, page 19. Para 19, sorry, page 69, para 19. For articles such as seized liquor, my lords get set.
Yes.
Articles such as seized liquor, also prompt action should be taken in disposing of it after preparing necessary panchanama. If sample is required to be taken, sample may be kept properly after sending it to the chemical analysis if required, but in no case large quantity of liquor should be stored at the police station for obvious reasons. No purpose is served by such storing. Next 20 melons. Similarly, for narcotic drugs also, for its identification procedure under 451, it should be followed for recording evidence and disposal. Its identity could be on the basis of evidence recorded by the magistrate. Samples also should be sent immediately to the chemical analyst so that subsequently a contention may not be raised that the article which is seized was not the same. This is how they dealt with it, my lords, in 2002. Now comes more large case, my lords. What happened in more large case? My lords would get it page 70. A respectful submission would be, my lords, more large case dealt only with the destruction of drugs, not with interim custody of vehicles. Please see, my lords, 2016, 3 SEC 379, Union of India versus Mohanlal. My lords, the relevant paragraphs. My lords can take page 80.
Apparently, this Mohanlal case pertains to only drugs.
Destruction of drugs, my lords. Because the whole problem they found in that case was large stock of drugs lying in police stations. What do we do with it? And that is how, my lords, they would give certain directions on it. And incidentally, somewhere, my lords, this usage of the word conveyance has now been wrongly construed to mean that it comes within the ambit of 52A. Page 80.
Which para?
Well, the very first paragraph we will see page 80, my lords. When this appeal came up for hearing before us on 11/4/2012, it was contended by the Learned Counsel for the Appellate Union of India that Standing Order 1 of 1989, which prescribes the procedure to be followed for seizure, sampling, safekeeping and disposal of seized drugs, narcotics and psychotropic substance is being followed throughout the country.
This is 89 notification.
89 notification. Second paragraph may be noticed, my lords. On 3/7/2012, this court, after hearing the amicus curiae, prima facie came to the conclusion that the procedure prescribed for the destruction, most important, my lords, procedure prescribed for the destruction of contraband seized in different states was not being followed, resulting in a frequent situation in which accumulation of huge quantity of seized drugs and narcotics has increased manifold the chances of its pilferage and recirculation in the market. And that, my lords, circulation, it leads to more drug abuse is what they told there, my lords.
Yes.
Page 81, paragraph 4. The queries raised in the court. Paragraph 4, my lords. The queries raised by this court were in the following words. 12.1 Seizure. What narcotic, drug and psychotropic substances have been seized in the last 10 years? Again, well, it's confining itself only to narcotic, drugs and psychotropic substances. 2. What are the steps taken again for narcotic and psychotropic? 3. What are the circulars, notifications, directions, guidelines, if any, issued to competent officers to follow any specific procedure in regard to seizure of contrabands, their storage and destructions? So, first is on seizure, 12.1. 12.2 is on storage of it, my lords. Questions that were raised on storage of it. 12.3, my lords, at page 82, disposal and destruction. What narcotic, drugs and psychotropic substances have been destroyed in the last 10 years? Everything is on destruction of the drugs, man. On the next page, my lords, is 12.4, judicial supervision. The court queries raised by the court. And my lords, paragraph 5. In compliance with those queries, my lords, various states, they've given their drugs and psychotropic, what all has happened, right from Andhra Pradesh, Assam, Bihar, Chhattisgarh, Customs, Central Excise, various states, my lords.
Yes.
They give details of the drugs and psychotropic substances. And then, my lords, page 98, para 11. Para 11. The last sentence in para 11, my lords.
Yes.
90. Last sentence in para 11. Having said that, we must mention that we are in these proceedings concerned with the following three issues only for the present. 1. Seizure and sampling of narcotic drugs and psychotropic substances. 2. Their storage. And 3. Their destruction. These were the three issues, my lords, in one.
Yes.
Now, seizure and sampling, my lords, they say how you could go about it from paragraph 12 onwards.
Solid.
Storage we get from paragraph 20 onwards, my lords.
Yes.
Disposal of drugs from but still there, everything was clear, my lords. Now, where the confusion arises is para 30. Paragraph 30 at page 105.
Yes.
Where the usage of the word controlled substance and conveyance came into picture levels. Para 30. In order to avoid any confusion arising out of the continued presence of two notifications on the same subject, we make it clear that disposal of narcotic drugs and psychotropic substances and controlled substances and conveyances shall be carried out in the following manner till such time the government prescribes a different procedure for the same. 30.1, my lords. In fact, what was to be for drugs and psychotropic substances, even conveyance was used there. 30.1. Cases where trial is concluded and proceedings in appeal divisions have all concluded finally. Fair enough, my lords. If it is concluded, even the vehicles were used, you can even destroy it. Fair enough, my lords. 30.2. Drugs that were seized after May 1989 and where the trial and appeal and revisions have been finally disposed of pertaining to drugs, my lords. 30.2. 30.3. Cases in which proceedings are still pending before the court at the level of trial court, appellate court, or before the Supreme Court. In such cases, the heads of department concerned shall ensure that appropriate applications are moved by the officers competent to do so under notification of 2015 before Drug Disposal Committee, and steps for disposal of such narcotic drugs, psychotropic, controlled substances conveyance taken without further loss of time. This is where the confusion happens. Now it is for disposal destruction. And what had happened is they used the wordings of 52A. Interpreted by a learned single judge of our court to say, in Mohanlals they also use the word conveyance. Therefore, you may have to go to a drug disposal committee. This is how it happened, my lords. Whereas the entire Mohanlals case, my lords, was concerned with drugs and psychotropic substances, how it has to be seized, stored, destroyed.
No, according to you, one law case doesn't applies. The NDPS Act, there is no provision contemplated for interim custody.
Absolutely, absolutely. No provision for interim custody even in Mohanlals case. And happy in the afternoon, my lords. I will point out how Sundarbai and Mohanlal has been construed by our court. What led to this reference?
Just went. Why? Good day for you on that day? 13. No, it will take, it will take. ಅವರು ಅಲೋ ಮಾಡಿ ಹುಡುಗರಿಗೆ ನೀವ್ ಯಾಕೆ ಬರ್ತೀರಿ? Don't take trains 2:30 onwards. Let them argue. ಬೇಕಾದಷ್ಟು ಕಷ್ಟಪಟ್ಟಿದ್ದೀವಿ ಅವ್ರು ಮಾಡಲಿ ಹುಡುಗರು. ನೆಕ್ಸ್ಟ್ ಡೇ ವಿಲ್ ಇನ್ವೈಟ್ ಯು. 13.
ಕೊಟ್ಬಿಡ ಹಂಗೆ ಅಲ್ಲ
ಬಂದ್ಬಿಡ್ರಪ್ಪ ಅಲ್ಲಿ ಮೇಲೆ ಬಾಯ್ ಮಾಡ್ತಾರೆ.